Welcome, curious minds, to another deep dive.
Great to be here.
Today, we're plunging into something really fascinating and, honestly, often turbulent. It's how our legal systems are trying to keep up with rapid change.
Yeah, it's a constant struggle.
We've got a stack of insights here that show the incredible pressures on our laws. Things like new technologies that just don't fit old definitions, attempts to streamline really complex government services, and even some deep questions about, well, judicial ethics.
It's really a powerful way to look at how society's evolving, isn't it? And it brings up big questions about how our legal frameworks adapt, or sometimes how they don't adapt to new realities.
Right.
We'll be looking at, for example, how different places are defining digital property. It's not as simple as you might think.
No.
And then there's the huge modernization effort with the U.S. Veterans Affairs appeals process.
A massive undertaking.
And the ongoing debates around ethics, both in the highest courts and, interestingly, in the tech world, too.
So our mission today is to cut through all that noise, find the really important bits, and hopefully give you that aha moment about this complex dance between law, tech, and society.
Definitely.
So grab your favorite beverage. You're about to get well informed on some pretty crucial legal shifts happening right now. Okay, let's get into it.
Let's do it.
Let's start with something probably right there in your pocket or on your computer. Digital assets.
Crypto, NFTs.
Exactly. Cryptocurrencies, NFTs, digital tokens, maybe even, parts of your social media accounts. But here's where it gets really interesting. Defining these things using traditional property law, it's proving to be a huge challenge.
It really is. What's fascinating is that the old ideas like chosen possession for things you can physically hold.
Like a book, yeah.
Right, or chosen action for legal rights, like suing someone.
Yeah.
They just don't quite fit the intangible nature of digital assets. They aren't physical.
They sort of challenge the whole idea of what property even is.
Precisely. Is your Bitcoin something you own directly, like your car? Or is it more like a right you hold, maybe like your bank balance represents a debt the bank owes you? It's a fundamental question.
Many people might know the bundle of rights idea from the U.S., property as rights, like use, exclusion, transfer.
That applies to tangible and intangible things, like IP.
Right. But how are different countries actually using that idea, or maybe ignoring it, when it comes to digital assets?
Well, when you look globally, it's a real patchwork. Different strategies everywhere.
Okay, give us some examples.
So take Japan. Way back in 2014 with the Mt. insolvency case, the Tokyo District Court basically said, look, we don't see crypto assets having a proprietary nature under our current laws. They couldn't really categorize them.
Didn't fit the boxes.
Didn't fit. Now contrast that with Singapore. They've been much more progressive, you could say.
How so?
Well, back in 2019, a court case, B2C2 Ltd v. Coin, actually affirmed crypto as an identifiable thing of value. It met their property rights criteria.
Wow, that's quite different.
And even more recently, in 2023, another case ruled crypto assets can be held in trust. So Singapore is showing flexibility, classifying things based on what they do, whether they act like property or securities, defining things like digital payment tokens. They're actively trying to build legal bridges.
Okay, so Japan's hesitant, Singapore's leaning in. What about, say, the UK or the EU?
The United Kingdom has also been pretty willing to recognize crypto as property. We saw a 2018 case grant a freezing order on crypto assets, treating them like other assets.
Okay.
And there was a really influential legal statement in 2019 from their jurisdiction task force. It wasn't binding law, but it heavily influenced the High Court later that year to say, yes, Bitcoin is property. That provided a lot of clarity there.
Right. And the EU, they often like standardization.
They do, and that's what the European Union is aiming for with MiCA, the Markets in Crypto Assets Regulation.
Yep.
Passed in 2023, fully rolling out by end of 2024.
MiCA.
Yeah, it's a big step. Unified rules across all member states, better consumer protection, and specific definitions for things like asset reference tokens, electronic money tokens. It's trying to create that single market clarity.
And then there's the United States. It always feels like a bit of a regulatory tangle there.
It is, yeah. It's more piecemeal in the U.S. Digital assets often get regulated based on how they function, so the SEC might step in if it looks like a security, using that Howey test.
Right, the investment contract test.
Exactly. Is it an investment of money, common enterprise, expectation of profit from others' efforts? If yes, SEC says security. Or the CFTC might see it as a commodity.
And the IRS.
The IRS taxes Bitcoin as property, that's clear. And FinCEN makes crypto businesses register as money services businesses, implement anti-money laundering programs. Similar rules to about 17 other countries, actually.
So less about one single definition, more about fitting them into existing regulatory buckets.
Pretty much. Though, interestingly, the Supreme Court even mentioned Bitcoin in an opinion back in 2018, sort of hinting at a future where maybe employees get paid in it. So the awareness is there at the highest levels.
Okay, there's one more major player, China. What's their approach?
China. Very different story. Highly restrictive. The People's Bank of China basically banned all crypto transactions and ICOs back in September 2021.
A complete ban.
Yes. They're focusing entirely on their own state-controlled digital currency, the DCEP. So a very controlled, top-down approach, opposite to most others.
Wow. So with all these different approaches, what does this actually mean for you if you're an investor or a company in this space?
Well, having clear legal status gives you clarity, security. It legitimizes things for companies. Without it, you get market volatility, innovation gets stalled because people are unsure of the rules, and there's a much higher risk of lawsuits. It's messy.
It really raises that big question. Can the law even keep up with technology that moves this fast?
That's the multi-billion-dollar question, isn't it? Legal experts are debating it constantly. Do we need a totally unique, sui generis legal framework just for digital assets, something brand new?
Well, can we just fit them into existing laws?
Right. Or should we adapt the laws we have? The trend seems to be moving towards creating clearer frameworks. Definitely more international cooperation is needed, and trying to make laws technology neutral. Meaning focusing on the function. What does this digital thing do rather than the specific tech behind it? Because the tech changes so incredibly fast. It's a constant race.
A race indeed. Okay, let's shift gears now. Let's pivot to a very different legal landscape, but one with huge human impact.
Yeah.
The massive effort to modernize the U.S. Department of Veterans Affairs appeals system.
Ah, yes.
The VA. For years, the VA was just known for these crushing backlogs. It caused so much frustration, real despair, for veterans waiting on decisions.
It wasn't just an inconvenience. These were life-altering decisions about benefits, healthcare, disability.
Absolutely. Waiting years, sometimes even decades. The Veterans Appeals Improvement and Modernization Act of 2017. The AMA wasn't just another law. It was a serious attempt to fix this.
And the scale of that challenge was just immense. But what's really striking is the progress they've actually made. The AMA gave veterans new options, crucial choices.
Like the higher level reviews?
Exactly. Higher level reviews, HLRs, and supplemental claims. These let veterans get quicker reviews directly within the Veterans Benefits Administration, the VBA, often without needing a full, formal appeal to the Board of Veterans Appeals.
So faster routes.
Faster routes, more direct pathways. It gives veterans more agency in the process.
And the numbers show these options are really being used, which is fantastic news. The rate of veterans appealing straight to the board, it dropped significantly, from 17% in fiscal year 2021 down to just 10% in FY 2024.
Most are choosing those faster VBA lanes.
They are, and it seems like the outcomes are better too.
Yes, significantly. Appeals under this new AMA system consistently have lower remand rates.
Meaning fewer get sent back for mistakes or more work.
Exactly. About 20% lower than the old legacy system appeals. And maybe more importantly, they have higher grant rates, about 8 to 10% higher.
So more veterans getting favorable decisions faster.
More favorable and more final decisions, getting them the benefits they earned sooner.
That's incredible progress.
Yeah.
And what about that giant backlog of old cases, the legacy appeals?
Huge reduction there, too. It went from over 472,000 cases back in November 2017.
Wow.
Down to just under 36,000 by December 2024. That's a 90% drop from fiscal year 2020 levels.
90%. That is a massive improvement.
Massive. And the quality metrics look good, too. The board's quality assurance for AMA decisions hit 95.4% in FY 2024, and HLR quality at the VBA was over 96%.
These aren't just stats. They represent real improvements in people's lives.
Absolutely. Trust being rebuilt in a vital service.
But despite all this progress, I imagine there are still challenges. It can't be perfect yet.
No, definitely not. The biggest remaining issue is that tail end of the legacy appeals. Even though the number is way down, it's still higher than they initially hoped.
Why is that?
Because these remaining cases are often incredibly complex. Many have been remanded multiple times, sent back down for more work or correction. Get this, 52% have been remanded at least twice.
Half of them.
Half. And 7% have been remanded 5 or more times.
Wow. Those must be incredibly tangled cases.
Exactly. They're the really stubborn ones, leading to continued delays for those specific veterans. Plus, the COVID-19 pandemic threw a wrench in the original timelines, too.
Right, that impacted everything.
And it raises that tough question. How do you clear out a really complex, decades-old backlog while you're also building and running a completely new system?
Like fixing the plane while flying it.
Pretty much. Plus, certain court rulings, like one called Beaudet v. McDonough, actually added more older cases to the pile by making certain caregiver program decisions appealable to the board retroactively.
So more complexity added in. Okay, so what's the path forward for the VA system and the veterans it serves?
Well, the VA is really focused on staffing, bringing in more judges, more decision writers. They're also constantly trying to improve their IT systems, things like case flow and the centralized mail portal, to speed up documents and enable more virtual hearings,
Technology helping streamline things.
hopefully. And they're tracking veteran satisfaction trust scores, and those are consistently higher under the new AMA system compared to the old legacy one. So it's this huge ongoing effort to transform a critical government service. It really shows how big organizations can adapt using laws and tech to try and deliver better for people.
That's a really important story.
Oh.
Okay, let's pivot one more time. Let's go right to the core of the legal system itself and some very visible challenges there. We're talking about the U.S. Supreme Court and, relatedly, tech antitrust.
Right, big topics.
There was a recent Senate Judiciary Committee report came out December 2024 after a long investigation,
9 months, yeah.
and it described what it termed an ethical crisis
Right.
at the Supreme Court, pointing to record low public trust.
The findings in that report are pretty stark. It details quite a few instances of what it calls ethical lapses, especially around things like lavish gifts and potential conflicts of interest.
What kind of examples did it give?
Well, it cited Justice Scalia, for instance, for accepting, allegedly, hundreds of undisclosed trips and gifts from billionaires who had business potentially coming before the court. It argued this violated federal law.
Setting a precedent.
A difficult precedent, yes. Then, more currently, it focused on Justice Thomas, reporting he allegedly ignored legal duties to disclose gifts, including some newly revealed private jet and yacht trips from Harlan Crow in 2021.
And there was the issue with his wife.
Yes, the report highlighted Ginny Thomas's involvement with the Stop the Steal movement, arguing this created a clear conflict of interest for the justice in related cases based on federal law.
Okay. Any others mentioned?
Yeah, Justice Alito as well. The report alleged he misused a personal hospitality exemption to avoid disclosing travel and lodging for a luxury fishing trip. And it also raised the appearance of partiality because of those Stop the Steal symbols seen at his properties while he was ruling on cases tied to the 2020 election on January 6th.
That's quite a list.
Yeah.
Now, what's really fascinating is the response, or lack thereof. The report basically called the Judicial Conference's reaction inadequate. Apparently, recent changes to gift disclosure rules actually expanded that personal hospitality exemption. Critics say that might end up excusing past behavior instead of tightening ethics.
Right. It raised eyebrows.
And Congress, they've tried to act.
There have been proposals, like the CERT Act, aiming to mandate a binding code of conduct for the Supreme Court, but that's been blocked in the Senate.
So it leaves this fundamental question hanging. What does all this do to public trust in our highest court, in our institutions generally?
It's a serious question. And some legal scholars, particularly those looking through a critical legal studies lens, might argue these aren't just isolated ethical slips.
But symptoms of something deeper.
Perhaps symptoms of deeper issues related to class, elite influence, access. Historically, the court's legitimacy has fluctuated, and these narratives, rigged robes or judges acting politically, judicial cosplay, they can really damage public perception.
So what's the recourse?
We're seeing strategic lawsuits and legislative pushes focused on the procedures, things like recusal standards, forcing judges off cases, and tightening disclosure rules. It's an attempt to force reform from the outside, focusing on the process to rebuild integrity.
A battle for institutional integrity. Now let's connect this to the tech world. We see similar themes of power, regulation, and trust playing out there.
Absolutely.
Around the same time the Supreme Court report was making waves, the Trump DOJ, in July 2025, reportedly fired 2 key antitrust officials.
Yes, that happened.
And the report suggested it was part of a wider move to maybe ease regulations, roll back some antitrust enforcement actions.
It created this interesting contrast, didn't it? Because while one part of the DOJ seemed to be pulling back, other legal actions against big tech were actually picking up steam elsewhere.
like the Google case.
Exactly. Federal judges have already ruled that Google willfully engaged in a series of anti-competitive acts in the ad tech market. So you have these conflicting signals within the U.S. system itself.
Which again raises a critical question. How do legal systems, especially ones subject to political shifts, effectively manage the enormous power of these giant tech platforms?
It's a huge challenge. And if you look comparatively, the EU has generally been much more proactive, much more aggressive in platform regulation. Think of the Digital Markets Act, the Digital Services Act.
Right, big legislative packages.
Whereas the U.S. has tended to be more, let's say, jurisprudentially cautious, relying more on existing antitrust laws and court interpretations, which can be slower and more complex.
And where is the focus of litigation now against big tech?
Increasingly, it's focusing on direct consumer harm. Things like manipulative user interface, design dark patterns, nudges, and data lock-in.
Meaning it's hard to take your data and leave.
Exactly. Making it difficult for users to switch platforms, which critics argue stifles competition and harms consumers. It's a very active, very dynamic area of law right now.
So wrapping this all together, what does this mean for you listening to this, navigating this world?
Well, all these examples, digital assets, the VA modernization, the Supreme Court ethics debate, tech antitrust, they're all snapshots of our legal systems really straining to keep up.
Straining under the pressure of rapid change.
Precisely. Societal shifts, technological acceleration, the ethical challenges at the court, the fights over tech power, they reveal these deep tensions about how power is used, how it's checked, in a world that's changing faster than ever.
And the outcomes of these struggles, they're not just abstract legal points. They'll shape legal precedent, sure, but also the very fabric of society.
They impact your digital life, your trust in the institutions that are supposed to serve you, even how basic government services function. It all connects.
What a journey we've taken.
Yeah.
Through some incredibly complex, really dynamic legal areas today.
We really covered some ground.
From how the law is trying to get its head around digital assets, to that huge job of modernizing the VA appeals, and then the ethical tightropes being walked by the highest courts and the tech giants.
Yeah. You know, what really stands out to me is this constant push and pull, this tension between the need for legal stability, for predictable rules, and the urgent, undeniable need for adaptation. The world isn't waiting for the law to catch up.
No, it isn't.
Yeah.
Whether it's defining new kinds of property or making huge bureaucracies actually work better for people, or just ensuring basic integrity in our justice system. These legal frameworks are under constant pressure.
Constantly being tested.
It really makes you think, doesn't it? How our laws, which can seem so fixed, so permanent, they're actually living things.
Or trying to be.
Trying to be. Constantly chasing after how we actually live and work and interact now. And as we saw today, sometimes that chase is messy, sometimes it's surprisingly effective, and sometimes it's just surprising.
Which leaves us with a pretty important question to ponder, I think. As technology keeps accelerating that idea of accelerating returns, and our social norms keep evolving so quickly, how much faster will our legal systems need to adapt just to prevent huge gaps in justice and security, in basic public trust? And what does that mean for how you have to navigate your own life digitally and as a citizen going forward?
Definitely food for thought. A lot to think about there. Thank you for joining us on this deep dive.
My pleasure.
Until next time, keep that curiosity well fed.